Hello viewers, welcome to my channel. I'm Hasham. So now I'm going to start the next important element of a valid contract. That element is consideration. So in this video, I'm going to explain you about the meaning of consideration, definition of consideration according to Indian Contract Act 1872, and what are the essential elements of a valid consideration. What are the essentials of valid consideration, and what are the different types of consideration I'm going to explain you. In examination, frequently they will ask the question regarding this meaning, definition, and essential elements of valid consideration. So watch the video till the end. Don't skip in between if you want the complete command on the topic of this Indian Contract Act. In all these videos, every time I'm taking one of the element. Last video I have completed offer and acceptance. So if you have not watched the last videos, I suggest you to go to the playlist of my channel. Select the subject business law. In that subject, you will find the first 2-3 videos. Watch those initial videos. You can be able to know the meaning of contract. What are the essential elements of a valid contract according to section 10? What is offer acceptance and what are the rules regarding offer acceptance? All these things I have explained in the last video. Now the next is consideration. So now I'm starting the meaning of the term consideration. Consideration is one of the essential element of a valid contract. Generally, without consideration, there is no contract. No consideration, no contract. Otherwise, a contract without consideration is void. So, consideration is one of the essential element of a valid contract. So, what is this consideration? It is something in return. When we give something, we should get something in return. So, that something in return is called consideration. So, every contract must have consideration. Technically, the meaning of the term consideration is quid pro quo. It's a Latin term, quid pro quo. That means something in return. That is called consideration. For example, Mr. A sells his bike for rupees 15,000 to Mr. B. So, Mr. A offers to sell his bike for rupees 15,000 to Mr. B. B agrees to purchase the bike for 15,000. So here Mr. A is promising to sell the bike to Mr. B, and Mr. B is paying the price, paying the cost, that is 15,000. That is the consideration. So from the promiser point of view, the price is the consideration. From the promisee point of view, the cost is the consideration. The thing which passes on from one party to another party is called consideration. That's all. This is the meaning of the term consideration. Something in return. In every contract, something should be exchanged between the parties. Now, in general, we can say an agreement without consideration is void. So, consideration may be defined as something in return. When we give something, we should get something in return. That is called consideration. Now I am coming to the definition given by Indian Contract Act 1872 regarding consideration. So section 2D, remember, we can write the meaning in our own way, but definition you have to remember as a student. In examination, you must quote the complete definition given by Indian Contract Act. Even the section number you have to remember. So here, according to section 2D, Section 2D of the Indian Contract Act defines when at the desire of the promiser. Remember, again, I am stressing on the words. When at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing such an act or abstinence, or promise is called consideration. Again, I repeat. So this is a big definition. That means in this definition, all the ingredients of consideration will come. What is that? When at the desire of the promiser, first of all, the consideration should be according to the desire of the promiser. The consideration should pass according to the desire of the promiser and the promisee or any other person. That means the promiser is making a desire to the promisee or any other person. That means the consideration may pass either from the promisee or any other person. Any other person has done or abstain from doing. That means the consideration may be past consideration, present consideration, or future consideration. That's why it is given has done or abstained from doing. This is past. Has done or abstained from doing. This is past. Or does or abstains from doing. This is present. Or promises to do or abstains from doing. This is the future. That means in this definition of Indian Contract Act, it has specified that consideration may be past or present or future. When at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstains from doing, or promises to or abstains from doing, such an act or abstinence or promise is called consideration. 3-4 times if you repeat this definition, you can be able to remember. You cannot cut short the definition because this is a definition given by law. So I have explained you the meaning of consideration is something in return. So in every contract there should be something given, there should be something received. So according to section 2D. Now example. Thirdly, I am giving you the example of consideration. A agrees to sell his house to B for rupees 10 lakh. Remember, A agrees to sell his house to B for rupees 10 lakh. Here B's promise to pay a sum of rupees 10 lakh is the consideration for A's promise to sell the house. A is promising that I will sell the house to B for rupees 10 lakh. B agrees I will pay rupees 10 lakh to purchase the house. So this 10 lakh rupees which B is paying to A, 10 lakh rupees is the cost of the house which is paying by B to A. That is consideration. That is consideration. So far here I have explained you the meaning of the term consideration, definition of consideration along with an example. Now I am coming to the next topic, essentials of a valid consideration. See, every consideration is not valid. Many considerations are there which will be unenforceable, which will be illusory, which is not enforceable. So when the consideration will be a valid, effective consideration, some points you have to remember. In examination, very frequently they will ask you, what are the essentials of a valid consideration? Now one by one I am going to explain you. It must move at the desire of the promiser. First point. The consideration must move at the desire of the promiser. Here in definition itself, first thing is that only. When at the desire of the promiser. That means the consideration always should go according to the desire of the promiser. Here in this case, A is the promiser. A agrees that I will sell the house to you for rupees 10 lakh. That means he is the promiser. Now the consideration should move according to the desire of the promiser. When A says A is the promiser, A's desire is you have to pay 10 lakh rupees to me, I will give you my house. So always it should be at the desire of the promiser. There is a famous case law on this first point. In a particular case, Mr. A is making some improvement in the market at the desire of the collector of the district. The collector of the district has made a desire to Mr. A to make some improvement in the market conditions. Now in this case, B promised that I will pay you some amount to A. B is promising to A that because I am the part of this market, I am using the market, I am having a shop in the market, so I agree to pay you some amount. Who is promising? B is promising. Later on, B has not paid. Now A sued in a court of law. Now court of law says at whose desire the consideration is passing? it is passing from B. But actually, who has given the direction to improve? Collector has given. Collector has given. That means consideration is not at the desire of the promisor. Promisor is collector. Promisor is collector. Collector is not saying that you have to collect the money from B. So, the first point, the consideration must move at the desire of the promisor. This is the first element of a valid consideration. Secondly, it may move from the promisee or any other person. According to English law, the consideration must move only from the promisee and nobody else, from no other person. The consideration should always move only from promisee. But Indian law says the consideration may move from the promisee or may move from any other person. The only thing, there should be consideration. We should not see who is providing the consideration, whether promisee himself or any other person. So simply, it may move from promisee or any other person. There is a famous case law on this point, Chinnaya versus Ramayya. In this case, what had happened? See carefully. An old lady. A is an old lady. So she promised, she has gifted the property. She has gifted the property to her daughter. The daughter's name is B. A is the old lady. So she has gifted her property to her daughter B, with the condition that from that property annually B should pay a certain sum of money to C, her aunt. C is the sister of A. C is the sister of A. So A is gifting the property to B on a condition that from this property every year you have to pay a certain sum of money to C. So she has entered into an agreement. B has entered into an agreement to pay a certain sum of money annually to C. That is the agreement. Later on, B has not paid. The daughter has not paid any amount to C. C approached a court of law. The court decided that on what basis she is not paying. B says there is no consideration passing from C to B. There is no consideration passing from C to B. So B says there is no consideration, so I will not pay. So court interfered and said that consideration is there. It has not moved from C, but it has moved from A. From A. So A, the old lady, has gifted the property to B. Consideration given by A to B. Now B cannot claim that no consideration is passing from C, so I will not give the allowance. No, she has to give the allowance because there is consideration. The consideration is not moving from C. Already it has moved from A. So what is the condition? It may move from the promisee or any other person. So two conditions. Third condition, it may be an act or abstinence or forbearance or a written promise. It is not necessary that something should be given. It should be an act. Even it should be an abstinence. Even if it should be a forbearance or a reverse promise, written promise, it will be consideration. It is not necessary that something should be done. Even if something is not done, that is also a consideration. That is also a consideration. There is a case law, again a case law on this forbearance. D is the wife. D sues her husband. D wants, ready to sue her husband. But husband says, I will give you a daily allowance. Don't sue. So husband is saying to the wife, don't sue me. I will pay you some allowance, household allowance monthly. Don't sue me. On that basis, wife has not sued her husband. She has not sued. So there is a forbearance. She has not taken any legal action against the husband. So that is the consideration. She has not taken. So it is not necessary that consideration should always be an act. It can be an abstinence. It can be a forbearance. That is also a consideration. It may be past, present or future. The consideration should not necessarily that only always it should be present. A past consideration also is a consideration. Also is a consideration. For example, A found B's purse, wallet, and A has returned it to B. Now B promised that I will pay you a certain reward because you have returned my wallet. You have returned my wallet. The already consideration was past one. So it is a enforceable contract. The contract between A and B. It is not a present consideration, it's a past consideration. Similarly, present consideration. A sells a bike, A sells his bike to B for rupees 50,000. So A is selling the bike and B is paying the price of 50,000 immediately. So right now itself the consideration is past. It is called present consideration. Future consideration. A says to B, I will deliver the goods in the next week. B says, I will pay the price after a fortnight. After a fortnight. That means consideration is going to happen in the future. So consideration not necessarily only present. It may be past, it may be present, or it may be future consideration. It need not be adequate. Very important. It is Indian law says there must be consideration. But how much consideration? The law is silent. The law says there should be adequate consideration. What is adequacy? That will be decided by the parties only. That will be decided by the parties only. The law will not interfere regarding how much consideration. Only if it is adequate, it's okay. Simple example I'll give you. A says to B, will you purchase my horse? Actually, the value of the horse is 5,000 rupees, but I am selling it to you for rupees 500. I want to sell it to you at rupees 500. B says, okay, I will purchase your horse for rupees 500. Later on, A refused. A says, no, I will not sell my horse at rupees 500 to you because there is inadequacy of the consideration. Consideration is not adequate. Earlier, I told you that I will sell at 500 rupees, but now I am realizing the actual value of the horse is 5,000, not 500. So I want to reject the contract. The court says no. The court says no, you are bound by the contract. The court will not interfere into the value of the consideration. As long as the value is there, then the contract is over. So it need not be adequate. Adequacy will be decided by the parties to the contract only. Next, it must be real and not illusory. The consideration must be real consideration. It should not be illusory. Illusory means imaginary. Example, A says to B, I will put life to your wife's body, dead body. It is illusory. It is illusion. Nobody can. Similarly, A says, I will take you a round trip in car to moon. It is illusory. Nobody can go to the car can go to the moon in a car. So it should be real. It should not be illusory. It must be something which promisor is not already bound to do. That means this consideration should be something which is not already bound to do by the promisor. Example, a public servant promises to do a public duty. Promises to do a public duty because public duty is itself, it's his duty. So when a person is performing his duty, it will not be a good consideration. It is already, he is bound to do that. Last one, it must not be illegal, immoral or opposed to public policy. That means the consideration should not be illegal. It should not be against the public policy. It should not be immoral. So these are the essential elements of a valid consideration. If these elements are lacking, then consideration is not called a valid consideration. Now last time. So I've explained you the meaning, definition, example, and also what are the essential elements. Lastly, I'm going to explain you about forms of consideration. The forms of consideration are executed consideration. Executed consideration means the consideration which was already over, either in the past or in the present. If the consideration already passed in the past or presently consideration is passing, it is called executed consideration. Executory consideration means consideration will occur in future. Example, A promises that I will sell you the goods after 1 week. B promises I will pay you after fortnight. That means the consideration will occur in future. It is called executory consideration. Past consideration, the consideration which had already happened in the past. Then unlawful consideration. Unlawful consideration means the consideration which is opposed to public policy, which will make some injury to the another person or the property of another person, or fraudulent in nature. These are unlawful consideration. Unreal or illusory. Unreal or illusory. Illusory means imaginary consideration. The consideration should not be illusory, should not be imaginary, it should be real consideration. That's all. So I have explained you about the meaning, definition, essential elements and forms of consideration. In the next video, I am going to explain you about the exceptions to the general rule, no consideration, no contract, and also the practical problems on consideration. So keep watching the continuation part of this topic of consideration in the next video.